Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this legal education content, please remember to subscribe. It helps the channel grow. For today's case, we're dealing with what qualifies as a disability for disability payments from the government. This is 2003 United States Supreme Court, Barnhart versus Thomas. In this case, a worker was disabled, but maybe only partially so, because the government thought maybe they could do a job that they used to do in the past. However, the job they used to do in the past, which is manually operating an elevator, is not exactly in high demand at this point in 2003. So the U.S. Supreme Court has to figure out whether or not their ability to theoretically do a job, even if that job doesn't exist, prevents them from getting disability payments. Let's get started with this. Pauline Thomas worked as an elevator operator for 6 years until her job was eliminated in August of 1995. In June of 1996, at age 53, Thomas applied for disability insurance benefits under the Social Security Act. She claimed she suffered from and was disabled by heart disease and cervical and lumbar radiochemotherapy, which I have no idea what that is, but we're going to take her word for it. After the Social Security Administration denied Thomas's application initially, and on reconsideration, she requested a hearing before an administrative law judge. The administrative law judge found that Thomas had hypertension, cardiac arrhythmia, and cervical and lumbar strains and sprains. He concluded that, however, that Thomas was not under a disability because her impairments do not prevent her from performing her past relevant work as an elevator operator. He rejected Thomas's argument she's unable to do her previous work because that work no longer exists in significant numbers in the national economy. The Social Security Administration Appeals Council denied Thomas's request for review. All right, so in 1995, she was, up till 1995, from 1989 till 1995, she was working as an elevator operator. And in 1995, she lost her job because not a lot of needs for manual operators of elevators. You know, for whatever it's worth, I can tell you one place that even today, uses an actual elevator operator to manually operate the elevator. And that would be the United States Supreme Court building. They do actually still have a manual person to operate the elevator. I'm not 100% sure why, but they do. So yeah, that's at least one place where that job is still used, but not a lot of them in demand at this point in history. So when she lost her job in 1995, she did something else that isn't specified here, nor does it particularly matter. And so she was unable to work this new job because of the conditions we just discussed. And she says, well, I'd like disability pay. And the Social Security Administration says, well, no, because you can't do the job that you were doing, but you could do light work, such as elevator operator. So you could do that. And she says, well, yeah, but no, because not a lot of elevator operators out there these days. And the Social Security Administration says, we don't care. You can theoretically do it, so that's good enough for us. So that's the issue in dispute. Let's read a little bit more. As relevant to the present case, the relevant law of the Social Security Act defines disability as an inability to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months. The definition, however, is qualified as follows. An individual shall be determined to be under disability only if his physical or mental impairment or impairments are of such severity that he is not only unable to do his prior work, but he cannot, considering his age, education, work experience, engage in any other kind of substantial gainful work which exists in the national economy. Work that exists in the national economy is defined to mean work which exists in significant numbers, either in the region where the individual lives or in several different regions of the country. So you may or may not be able to spot the issue here in the statutory text, but that's why we're here to be able to illustrate it. So what is the problem? Well, this statute seems to have two different things, two different parts, or maybe it doesn't. It's an issue of statutory interpretation. What does it mean? So you're disabled if two things maybe are true. One of those things is that you're not able to perform your previous work. And the other would be that you're not able to perform other work that exists in the national economy. So that is a potential problem. Does the previous work have to exist in the national economy or not? Right? Because these might be two separate things. So it says, can you do your previous work? If not, can you do work which exists in the national economy? And so maybe it matters if your previous work exists in the national economy, and maybe it doesn't matter if it exists in the national economy because of the way this is phrased. This goes to show you that when you're writing these things, words do matter, statutes matter, and so now we have to interpret what this language means. Did the Congress, in its infinite wisdom when they wrote this, did they mean that if you were able to perform your previous work, it doesn't matter whether it exists or not? Or does it matter if it exists? All right, that's the issue. Let's figure it out. The relevant law establishes two requirements for disability. First, an individual's physical or mental impairment must render him unable to do his previous work. Second, the impairment must also preclude him from engaging in any other kind of substantial gainful work. The parties agree the latter requirement is qualified by the clause that follows it, which exists in the national economy. The issue is whether that clause also qualifies prior work. So there are two different phrases. Exists in the national economy definitely modifies the second. Doesn't modify the first. Okay, so, all right. The Social Security Administration has answered this question in the negative. So the Social Security Administration says no, that it exists in the national economy does not matter when it comes to your previous work. Acting pursuant to its statutory rulemaking authority, the agency has promulgated regulations that establish a 5-step sequential evaluation that determines disability. So the Social Security Administration has to implement the statute, and so they've put in place some rules. And the rules in substantive part say it doesn't matter if your prior job continues to exist. As long as you could do it, you can't get disability, even if it doesn't exist. The fact that it doesn't exist is your problem, not our problem, because of the way the statute's written. All right? As the above description of the Social Security Administration's regulations show, Step 4 of the Social Security Administration's analysis can result in a determination of no disability without any inquiry into whether the claimant's previous work continues to exist. The regulations explicitly reserve inquiry into the national economy for Step 5 of this particular analysis. Thus, the Social Security Administration has made it perfectly clear it does not interpret the clause which exists in the national economy in the relevant law as applying to the previous work. The issue presented is whether this agency's interpretation must be accorded deference. All right, so now we now have the issue that we all know and love here on Uncivil Law. We have administrative deference. Yeah, so the Congress wrote a statute. The statute may have some problems with it because Congress doesn't always know how to law, which should surprise nobody. However, their inability to know how to law unfortunately doesn't impact the laws that they pass. Even if they don't know what they're doing, they do stuff. And the stuff they do matters. So maybe they should learn how to do law better, but the fact they don't know how to do law is unfortunately not the Supreme Court's problem. Figure out how to do it better. But you wrote the statute you wrote. And so the Social Security Administration is going to go implement this statute that Congress wrote, and the language is open to potential interpretation. And the Social Security Administration has taken the position that the existence of the job in the national economy does not apply to the aspect of the previous job. So does that matter? As we held in everyone's favorite case, Chevron. Chevron appears because of course it does. When a statute speaks clearly to the issue at hand, we must give effect to the unambiguously expressed intent of Congress. But when a statute is silent or ambiguous, we must defer to a reasonable construction by the agency charged with its implementation, including if that reasonable interpretation changes for any reason. Because, that's how this works somehow. The Third Circuit has held, by referring first to previous work and then to any other kind of substantial work which exists in the national economy, the statute unambiguously indicates the former is a species of the latter. So the Third Circuit said that the Social Security Administration was wrong. The Third Circuit writes, when a sentence sets out one or more specific items, followed by any other and a description, the specific items must fall within the description. We disagree. For reasons discussed below, the interpretation adopted by the Social Security Administration is at least a reasonable construction of the text and must be given in effect. So, yeah, the Supreme Court says, the Third Circuit said, no, this phrase clearly applies to the first clause. And the Supreme Court says, no, it's ambiguous. And sadly, I'm forced to agree. It is ambiguous. You could read it that way, or you could not. And yeah. So the Supreme Court is, of course, right, as sad as that is. And it just goes to show Congress doesn't know how to law. I don't know that Congress intended this result, but for better or worse, that's the one they passed. So what can you do? The Third Circuit's reading disregards, indeed is precisely contrary to, the grammatical rule of the last antecedent, according to which a limiting clause or phrase, here the relative clause, which exists in the national economy, should ordinarily be read as modifying only the noun or phrase that immediately follows, here any other kind of gainful work. So yeah, there is, as always, rules of canons of construction, rules of statutory construction. There are many different rules, and one of these rules is, if you have a phrase that's followed by and other stuff, the and other stuff is read in light of that phrase, whatever it is. It doesn't go back to prior phrases, right? It doesn't proceed back beyond its own sort of domain. So yeah, you could say, what would be a good example? No cars in the park, and no dogs, cats, or other animals. So you would say that animals is relative to dogs and cats, not relative to cars. Yeah, because it doesn't proceed back its own terms. So yeah, in this case, you would normally read it only as part of the phrase to which it belongs, and the phrases are separated, so therefore it doesn't modify the previous employment phrase. Makes sense. The court could conceive of no plausible reason why Congress may have wanted to deny benefits to an otherwise qualified person, simply because that person, although unable to perform a job that actually exists in the national economy, could perform a job that no longer exists. Yeah. And then on the next page, they come up with a reason, because in the vast majority of cases, if you're able to perform your prior job, even if it doesn't exist, it strongly implies you may be able to perform other jobs, even if that exact job doesn't apply. So yeah, the Third Circuit said we can't think of any reason Congress would want it this way. And the Supreme Court says, yes, you can. You can think of a reason. You did think of a reason. If you're able to perform your prior job, even if it doesn't exist, it suggests you may be able to perform other jobs. Yeah. The conclusion which follows that Congress could have determined that analysis of a claimant's physical and mental capacity to his prior work would, in the vast majority of cases, serve as an effective and efficient administrative proxy for the claimant's ability to do some work that does exist in the national economy. Such a proxy is useful because the five-step inquiry into whether the claimant's cumulative impairments preclude him from finding other work is difficult, requiring consideration of each of the vocational factors and an individual assessment of each claimant's abilities and limitations. So the Supreme Court argues that Congress intended this result. Whether or not that's true, who knows? Also, it doesn't really matter to an originalist or textualist, right? Because we don't do what Congress intended. So depending on where you are on the interpretive paradigm, right, what Congress intended may or may not be of interest to you. It is of less interest to more conservative thinkers. We go more about the original meaning, not original intent. So what Congress meant and all is super interesting, but not that interesting to conservative thinking. So if you're thinking, well, intent should more matter, then you're probably more on left-leaning legal thinking. To a conservative legal thinker, it's like, yeah, original intent's interesting and all, but, we look at the text and the original meaning there too. And not really what Congress was really hoping for, although, the boundaries of these are obviously not clear. It's not like black and white. It's not like something you just turn on, turn off. So it's more of a, gradation. But more conservative people hold in less regard intent at a minimum. Let's go with that. The proper Chevron inquiry is not whether an agency construction can lead to an undesirable result, which, because maybe, that's Congress's problem. And both constructions could lead to an undesirable result, depending on what you consider desirable. So yeah, what you consider desirable is kind of an unsolved question here. So either construction may lead to an undesirable result depending on what you desire, but rather whether in the light of the alternative, the agency construction is reasonable. In the present case, the authoritative interpretation certainly satisfies this test. And as I was indicating before, I actually have no particular problem with this, and that's kind of unfortunate because I hate Chevron. I hate Chevron so very, very much. But, as long as Chevron continues to exist, what do you want from me? I'm just here to apply the law. So yeah, the way that the Social Security Administration parks this is reasonable. Chevron applies, bing, bang, bong. You can't get your disability payments. That makes total sense given the state of the law. Yeah. Thus, that brings us to the end of the case of Barnhart versus Thomas, a 2003 U.S. Supreme Court case. In this case, we learned that Thomas had some disabilities, but it didn't prevent her from being an elevator operator. And she says, well, there's not a lot of job for elevator operators anymore, so I should have disability. The Third Circuit says you're right. The Supreme Court says no, not so much. The clause is ambiguous, and the way that Congress wrote it could make sense. The way it's interpreted could make sense. There could be a reason. So you either become an elevator operator or something, but you don't get disability payments because you still can work. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.